Division Bench, Item 1, Contempt Case Criminal Sumotu 1/2025.
Wait, please, Good. This is second offense, my lord. I have seen that earlier. He has been convicted for 6 months, and that is that bail bond was, my lord, that is suspended for 4 years. And now, my lord, he is doing same again, my lord. And probably, my lord, he has not read the Bar Council of India rules, my lord. My lord, very clearly, my lord, it is mentioned the duty towards the court.
Yes, we are aware.
Duty toward the court. If he is not satisfied with any order passed by the court, then he has a go for appeal. There's a procedure. And he is not satisfied with any, my lord, conduct of the, my lord, trial judge, then he can make a complaint. There's a procedure. But why he should go to the social media and this type of comment has been made, my lord. Probably solemn notice be issued.
Which is the offending portion of the Facebook post?
Facebook was offending, but he made a post, my lord. Yes.
Offending.
Fatmela Behumati Patala Lukao. There is a page 14, my lord.
Which one?
Page 14, my lord.
Yes.
Aji Civil Judge Junior Division number 2, Srimati Swenso Praikha, their right to salute. Tekhete likhise, height order that it was specifically stated that the mandatory notice under the section 80 CPC was served upon Deputy Commissioner Jorhat in his official capacity and not as a representative of State of Assam. সেইকাৰণে আমাক ষ্টেট অফ আছামৰ কেছত পাৰ্টি বনাম নতুনকৈ ডেপুটি কমিশনাৰ এজ এ ষ্টেটেড ইৰেসপেক্টিভ বুলি লিখি নটিচ দিবলৈ কৈছে। ফাটমেলা বসুমতী পাতালে লুকাও ডেপুটি কমিশনাৰজন অফিচিয়েল কেপাচিটিত ষ্টেট ৰিপ্ৰেজেণ্টেটিভ নহয় নেকি বাৰু? যদি নহয় কিয় কেপাচিটি তেখেত ষ্টেট ৰিপ্ৰেজেণ্টেটিভ হয় বাৰু? মহোদয় মিটিনে সম্বন্ধীয় হিচাপে হ'ব পাৰে। আপুনি কি ভাবে জনাবচোন? My lord, that is directly, my lord, allegation made to the why I am submitting, my lord. Because your lordship kindly see the derogatory remark he is made in the public. As a counsel, he has a duty towards the court. Again, I am submitting, my lord. If he is not satisfied with the order passed by the Lana trial judge, he can make an appeal. He can.
Criticism?
No, fair criticism is okay. But it is directly, my lord, it is accusing the court. Judiciary, my lord.
Court have not realized the difference between a deputy collector and a deputy commissioner.
My lord.
Although you have also to see what is the course of action which was necessary on the part of the judge concerned. If a section 80 notice is required, what is to be done?
No, that is the so far is merit of the case.
No, I am saying what should have been done. Normally.
No, if notice is dismissed, my lord. If not, yes, that's mandatory provision is not there. That is dismissed, my lord. Correct.
Can court insist?
A court cannot, but court if so advise.
Court, except the Supreme Court, there is no advisory.
My lord.
So the court can.
No, my lord, my submission before your lordship is that, my lord, once he has already been convicted by this honorable court, he should be very careful in handling this type of situation, my lord. That person. That is, my lord, at least that his probation period is not yet over, because that bail bond was, my lord, probably for 4 years. 4 years it has been stayed, my lord. Your lordship kindly see. During that period, my lord, it should be.
Therefore, we are more concerned. He is on a waiting thread on which he's
yes.
Out there.
Yes, my lord.
So it has to be more concerned, because the moment we convict him, immediately he goes for.
Yes, that I understand, my lord. Yes.
See the way
So let's notice we should see what is his reply.
It's a between.
No, I got my point. Your point.
You see, the comments he made at that point of time was very dangerous.
No, that's very correct, my lord. Your lordship, my lord, trial judge, my lord. Yes, he instead of giving him advice, my lord, straightway dismiss. There is no notice under ATCPC, not so it is not maintainable. Straightway. That was not done. Suppose not done. That means it's a wrong order passed by the Lana trial judge. Then you can go for appeal. He can agitate the matter of proper forum. Or if we have any complaint against the judge, there is a procedure. Then in fact, my lord, in the
For that, why at the bar council,
no, bar council, my lord, until and probably so much of power they have not exercised till, and I have not seen, my lord.
No, I'm asking, see, you are saying that there is a violation of the bar council.
Yes,
So then why the bar council is not taking effect? After having a conviction.
my lord.
The conviction, just standing from the conviction which is going on for the next 4 years, this conviction is going to happen.
My lord.
If he is again guilty of another contempt,
My lord.
then
Yes.
immediately he will be sent. It has been already held. That's why the bar council is not taking up action.
Bar council, my lord, if somebody complain, my lord, definitely then taken up. But so much I have not seen, my lord, till today. Taken up by the bar council, my lord. No, your lordship kindly see the rule governing the advocate, that is, my lord, chapter part 4, my lord, of the Bar Council of India rules, my lord. Standard of professional conduct and ethics. The first, my lord, first section 1, that the duty to the court.
But we wonder whether the duty to the court is not done.
No, that duty to the court, that is a duty cast upon the advocate, my lord.
Amount of contempt.
My lord.
That is
There's a
the
violation of the, your lordship says that there is a violation of the Bar Council of India rules, that why Bar Council is not taking it. Then your lordship can refer the matter to the Bar Council, my lord.
First, let us hear the other.
My lord.
Mr. BJ Mathur, and that's senior counsel. And senior counsel, assisted by his P. Sharma, London. Acting counsel. Almost standing counsel for the High Court. Senior standing counsel.
You are Miss Senior Standing Counsel for the High Court?
My lord. My lord, please.
The Lalit senior counsel has submitted that the respondent has already been held guilty of contempt of court by order dated 9/3/2023. Sorry, 21/4/2023, passed by this court in on case within bracket criminal, within bracket Sumoto 1 of 2022, page 23. So, however, the Sentence was suspended for a period of 4 years. By providing that if within the said period, the respondent is convicted for any other offense under the Contempt of Courts Act, the sentence will be activated. Next, it is submitted that once again, the respondent has committed contempt of court, which is brought to the notice of the registry by the civil judge within bracket junior division, bracket closed, number 2, come judicial magistrate first class Jorhat, by letter dated 4/11/2025. And accordingly, this suo motu contempt case has been registered. Next one, the Connect Senior Counsel has submitted that in the event the respondent was aggrieved by any order, there was a forum available to agitate to assail the said order, instead, the petitioner, the respondent has made comments in the social media so as to disrepute the court. Next one. As privacy cases being made out, issue notice returnable on the date after 4 weeks, returnable on so and so. The registry shall take steps for service of notice on the respondent by registered post with AD, as well as by usual process to be served through the jurisdictional court. Next paragraph. List on so and so awaiting service of notice and for appearance of the respondent.
6th of February.
Developed.
Yes.
With due respect and consent of the other side, I beg to mention item number 25. The matter is relating to my lord police arbitrary action and the quashing petition was partly allowed here and the petitioner has approached the Honorable Supreme Court. This stay has been granted, but my lord 3-4 times the learned counsel for the state of Assam, he has taken adjournment. Therefore, unless that petition is disposed of, it will be not advisable to hear this petition. Therefore, your lordship may kindly allow at least 4 to 6 weeks time so that the matter is disposed of there, then we can take up the.
Both sides are represented on the prayer made by Mrs. N. Saikiel and counsel for the petitioner. The matter stands adjourned today. List after 4 weeks.
6 weeks. 6 weeks.
6 weeks. Liberty to both sides to make a mention if the matter is not listed
Yes, my lord.
within a reasonable time.
Obliged. Happy New Year to both of you, my lord.
That's right. Same to all the members of the bar.
Thank you. Very clear, Lordship. Item number 21, Lordship.
41.
Eligible for total, Lordship.
Item?
21.
2019 matter. Okay, give a fixed date after 2 weeks. Okay, represented on the prayer made by land council for the petitioner, list also and so.
21. Next.
21. Next. Friend intends to mention.
Your Lordship, item number 22, sorry, 32, Your Lordship. I beg to mention with the consent of the other side, as the mediation is going on and the next date is 21st January 2026, Your Lordship.
We did not get, please repeat again.
Your Lordship, in this case,
Mediation is going on.
yes, Lordship, and the next date is on 21st January.
21st January.
Yes, Lordship.
Yes. According to both of you, is it progressing in the desired manner?
Millard,
Or is there still a stalemate?
few steps have been made, Millard, but
Stalemate is there still.
it's Millard, I think the next step that they take will actually give us an indication whether there is some scope for a fruitful outcome, Millard.
Will break the glass ceiling.
We have been in fact, Mr. Saiwala and myself, Millard, we've been putting as much as we
Very
can,
good,
Millard.
very good.
pressure
So you
we
see,
can.
we are thinking of the child.
Yes, exactly.
That is
Millard.
the paramount issue before us.
That is the sole, Millard, genuine consideration, Millard, for both sides.
That's why I still remember, we also suggested that song should be heard first
My lord.
for every mediation sitting. You hear, ask both sides to hear a song and then come for.
The learned mediator also has been making, Millard, good
Very-
efforts,
very
Millard.
good. Very good. Both sides are represented. You will record your name since you are from opposition. Your name?
Ms. K. Sharma.
Ms. K. Sharma, Learned Counsel, appearing on behalf of the Learned Counsel on record for the petitioner, submits that mediation process is going on and the next date is fixed on 21/1/2026. Next one, Mr. A. Fokal, Learned Counsel, appears for the respondent. Next matter stands adjourned today. List again on.
May I request 27th of February, possible, Millard? I can be physically present, Millard.
Okay, 27th February,
February.
2026. Waiting report of the mediator.
Deeply obliged. So, Millard, if there's another session required, we can do that also, Millard, before. Deeply obliged.
Item number 9, Millard. It may be taken next. Millard.
9 is a motion matter. We are not adjourning it.
Yes, sir. TCR has been received,
No,
Millard.
whatever we, but we will have to look into it. You wait for your turn.
Lordship, I beg to mention item number 19, Lordship. Affidavit will be filed, government, Lordship.
You have filed
No, Lordship, it will be filed within 2 days.
within 2 days, just 2015 matter.
Item number 9.
19 just.
It's prepared, Lordship. Today or tomorrow it will be filed, Lordship.
We provide that if affidavit is not filed within 2 days, there will be a cost of 10,000 to be realized from the concerned officer.
Okay, Lordship.
You take it up. You suggest a date when we should take it up?
Friday, Lordship. Five. 9 lots.
Listing it immediately after view. 19,
19 lots.
both sides are represented. Mr. N. Tarita will nominate advocate pays for further 2 days time to file affidavit in opposition by respondent number 6. As this is a matter of the year 2015. It is provided that if an affidavit in opposition is not filed within 9/1/2026, the court proposes to impose a cost of rupees 10,000 on the state to be realized to the concerned official who is in default in filing the affidavit in opposition. Next paragraph, this on 19/1/2026.
That's okay.
The government advocate shall transmit a copy of this, downloaded copy of this order to the concerned authorities. Bring the order to the notice of, to their notice.
Yes. So that's okay.
May I please, His Lordship? I beg to mention item 6 and 22, Lordship. Lordship,
This motion matter, you will have to wait, not adjourning it right now.
yes, Lordship.
Item, next item.
22, Lordship.
22. Give the same date. After 2 weeks.
Must be
Met
yes.
pleasantly. Lordship, with the consent of other side, I beg to mention item number 30, your Lordship. Lordship, learned arguing counsel MSD.
You will have to wait, it's a review matter. You will have to wait till the matter is called.
Lordship.
Yes.
Please, Your Lordship, I beg to mention item number 17, my lord. To the adjourn the matter because my senior out of station, my lord.
17 is a motion matter, no. Wait for your turn.
Senior out of station, my lord.
Okay. Motion matter, we are not adjourning.
Daily list, item 1 for motion.
May it please, Your Lordship. In this matter, Lordship, on 8/4/2019, records were called for, but no notice was not yet issued, Lordship. Bail was granted, there was a mistake, so that was corrected by filing an interlocutory application, Lordship. The second order was passed on 6/5/2019, and thereafter, Lordship, on 2 dates, the matter was listed. But sometime we took time and sometime due to paucity of time, matter was not taken, Lordship. She is on bail and she contested the case, Lordship, the petitioner. Impugn order is at page 37, annexure 12.
In your written statement, I
No.
have given the date of death of your father.
Lordship, in my in my read petition, I have stated that after her birth, Lordship, after 2 years of her birth, the father died, Lordship. Page 5, paragraph 3, I have mentioned that the petitioner was born around the year 1972. Within 2 years of her birth, her father died, and within next 1 year, mother of the petitioner also died. And as such, their names no longer appeared in any voter list after 1970. And she was brought up by her uncle, Lordship Kolimuddin, and subsequently the petitioner was married with the son of Kolimuddin, Lordship. So her name appeared for the first time in 1997 voter list, along with her husband, Lordship, at the age of 25. But learned tribunal held that the voter list along with her husband cannot be taken into consideration to show linkage with her father, Lordship. And Jamabandi,
Getting any connect with your father,
yes, Lordship, land documents are there.
but land document you see, you know. You come to page, you
Page-
have a copy of the exhibit D, Patta?
Yes, Lordship, page 19. Only difference is that Lordship 1966 and 70 voter list, her father name appeared as Rustam Sheikh and the land document is Rustam Ali, Lordship.
No, you see, something else has happened in the meantime. This page 19 would show that the name of your father was deleted and this Patta was issued to you. This is the 31st March 1990, sorry, 2009. This page 19 is a rubber stamp imposed there, 31 March 2009.
Yes, to Lordship, the patta was issued in the name of her father along with his brother Lordship Kolimuddin.
No.
But
See, that's what we are trying to ask you. You see, in this Patta,
Lordship,
the name of number 1 has been deleted. That is perhaps your father. And
yes,
the Patta starts from the name of number 2. That means what has happened, this deletion of name of your father happened in 2009.
Lordship,
Because otherwise the Patta would always have the name of
Lordship.
the Patadar.
By that time, her father died, Lordship.
We understand.
Lordship,
But now you see in the Jawabandi,
Lordship.
which is at page 22.
Yes, Lordship.
Now you find that this order
2016.
is 2016,
Yes, Lordship.
inconsistent document. In
Lordship,
Patta,
as
the name could not have been
mutation-
deleted.
Lordship, mutation was done subsequently, Lordship, as
We don't know. You see, so
Lordship.
far the little of land law we know,
Lordship.
the name deletion would take place only on the basis of some order by the authorities. So
Lordship.
number 2 is deleted. And then comes this mutation order of 2016, and thereby this name of Asma Khatun has been inserted. This creates a doubt.
Lordship, in
Issue notice,
page,
since the records are there,
Lordship,
Mr. Faiz?
page 19, Lordship, deletion part, in my copy, there is no deletion part, Lordship. মই ওপৰত লিখা জিলাৰ ডেপুটি কমিশনাৰে ইয়াৰ দ্বাৰাই প্ৰচাৰ কৰোঁ যে প্ৰাদেশিক গভৰ্ণমেণ্টৰ পক্ষে এই পট্টাৰ হিপিঠিৰ তফচিলত থকা মাটিখিনি 31 মাৰ্চ 2009 চনৰ জুলাইৰ পৰা
So this means you see, Mr. Chaudhary, you know the civil law.
Lordship,
We don't have to tell you much.
Lordship,
Now in this Patta, there is only one name.
Lordship.
By a mutation order of 2016, another name could not have been inserted.
Lordship.
As legal heir of Patadar number 1, whose name has already been deleted in 2009. And then if you claim through Kalimuddin is your
Uncle,
uncle.
Lordship,
So now if your name is inserted, your name will be inserted as a legal heir of Kalimuddin, not of your father.
Lordship.
That's the difficulty, but today, first day, we don't want to disappoint you. First day of year.
Oh,
First day, we don't want to disappoint you.
Lordship.
It also the representation. as the records of the tribunal is the same, court is inclined to issue a rule returnable without requiring any first steps to be taken. Next, this is the matter for hearing the week commencing 2/2/2026.
Motion. Obliged.
Item 2.
Only here's a call for the petitioner, how all the respondents are represented, as the record of the tribunal is received. Court is inclined to show no returnable document, the filing steps to be taken, please. Next. It is provided that in the event the petitioner remains absent on call on the next date of listing, I advise notice will be followed. Next, this is the matter for hearing in the week commencing 2/2/2026.
Item 3.
May I plead the lordship?
Yes.
My lord, the impugned judgment is as case 41, my lord.
Page number?
Page number 41, my lord. It starts at 41.
Well, you see here what has happened, you come to page 43. Para 6.
Yes.
Please tell me if my view is incorrect. You see, what happens is that the tribunal accepted the evidence.
Yes.
There was no objection raised with regard to the admissibility or the mode of proof. But in the, at the end, it says that since there are fake documents available, therefore rejected. Then I think you should get an opportunity to prove the, or for the original and prove it. Because either you, the tribunal should apply the judgment of this court, saying that since these are certified copies were not proved in accordance with law, you will reject it.
That's
But because there is a fake documents available, for that there must be some evidence before the tribunal.
Yeah, understood. My lord, even though this,
I can expand it with another horrible example.
yes,
You see, someplace in Madhya Pradesh, a lawyer makes a false statement before the court and his contempt is drawn up and he is convicted for committing offense of contempt of court. Not just because of that, can I today question Mr. Pai and say that, well, one advocate has already been convicted, you also may make a wrong statement and therefore I disbelieve you. No, I think that is not fair.
yes, I understood, my lord, that is true. Otherwise also, my lord, even though we accept the voter register there, my lord, only question here is whether she could establish her link.
But we will not give the original judgment here. The original opinion has to come from the tribunal.
Otherwise, my lord, from her birth certificate and her marriage certificate, the link is well established.
No, we have a doubt. We have a doubt. There, technically, we are with Mr. Payam, but sorry, legally we are with Mr. Payam, but technically we are not.
Yes,
Because the fact is that the tribunal should give a opinion, not us.
yes, my lord.
If it is fake, then you catch that fake person and he should have been arrested there and then.
Yes, yes,
It's a
my lord.
fake document.
Yes, my lord.
And these certified copies are, there is no judgment of this court. I think the certified copies must be looked by the original. It says that if it's a translated copy, then it should be proved through the, by calling the original records. And certified copy, if you have doubt, definitely original can be called for.
But in case of the voter list, there are some judgment of this honorable court with regard to foreigner cases only. My lord, I'm not concerned with other cases. The certified copies, the voter list may be, my lord, compared with original. There is 1, 2 judgments on that, my lord. The issue was that only, my lord, exactly the same what is described in para 6. My lord, that there are some documents which are, my lord, doubtful. So it may be my lord, compared with the original, my lord.
Which is the one,
Yes.
which is the judgment you are referring to?
Para 6, my lord.
No, no, the judgment.
Judgments, my lord, I can provide, but as on now, I don't have, I provide it. I can provide it. Because the copies were, my lord, available everywhere. So
Yes. Okay, para 19 onwards of this. Let me ask you. That is here on Nessa.
Yes.
4 paragraphs.
Yes, I have control. So this is true, madam. This is,
So this is not the compared copy. This is the,
This is-
in this case, the.
It is certified.
Is certified copies.
it is certified copy.
Yes. Please make, you can always request the superintendent of police to examine the document.
That is true, my lord.
If there is a doubt, we always done.
Yes, no, that is true, my lord. If there is doubt, that has to be, in fact, your lordship is correct that objection should come in the first instance itself. That is,
Even if not.
yes.
Even if not. You see, I just can't disbelieve you because just before you, somebody else has misled, tried to mislead us.
Yes, madam.
That doesn't make, I cannot generalize and then say, I am not hearing you because you may also do the same thing.
I'm agree with you that proposition, I'm agree with you, my lord. That is true. But yes, there is a judgment, my lord. Probably I had that reasonable court person judgment where it is said, my lord, the voter lists are available in public domain. So so it is better to compare with the original one. There is a judgment of reasonable court. That's why.
That's true, but it is better.
Yes.
Better does not mean it's a law laid down. Because that, you see, that's why these things are not a part of the Ordinance Tribunal rules.
Yes.
It says it's a civil code for the purpose of Order 4. And you know, with the, I'm sorry to say, but with the continuous lowering of standards in the advocacy in the foreigners tribunals cases, specifically. These are not laid down well in
Yes.
written judgment. Then nobody reads those and they will make mistakes.
No, this is, my lord, this is,
I
my lord,
can give you the data of GLR and GLT being subscribed by the lawyers in the district courts. It's not happy. Even in our court, is the highest court in the state. Here also there is a very low purchase of law books. Therefore, many lawyers are not updated.
Yes.
I'm sorry to say that. But we go by the data. Neither e-subscriptions are there, nor what they call the purchase of books are there.
That is.
That's why we insisted this tribunal should have the books. That's why we gave directions in the monitoring bench. Otherwise, if the books are not, even if now we are finding that even if the books are there, they are not reading it. Okay, we'll take it up at 2 o'clock, try to find out if we
Yes,
can
yes.
give the judgment.
Yes,
Otherwise, we'll put
I'll
something there.
provide.
That is,
Yeah.
judgment has been delivered by Mr. Vijay.
Yes, it is. Yeah, I'll get it.
Try to see that and then.
Yes, yes.
Public.
Black.
Item 4.
May I see the lawsuits? This case initially on 24 to 19, LCR was called for and I was protected, not to be arrested. But due to impendence of the case, I was arrested, I filed IA and it was disposed of and released.
Which makes the opinion.
Opinion is at page 48. My father also made evidence lawsuits. It was not also considered. I find only discrepancy of name in the age and in the book. Family lawsuits. That's why not considered lawsuit. Discuss the evidence. Evidence of the computers such as of the section 160. 74 also something. Lordship, written statement is at page 34.
So Barbara,
Lordship,
same thing. We don't want to disappoint you today in the first day. We listed for hearing on 2nd of February.
second
There's
week
a
of February.
disconnect because it's not mere mistake in the difference in the names. The discrepancies you have not even referred to in the written statement.
My grandfather's name clarified Intulla Inudevani's full names of written,
In your written
But-
statement is not there.
and the
No
evidence,
explanation in the written statement.
and the evidence found, Lordships, it was not challenged and no cross-examination, so my father evidence
Required.
also not been,
Not required.
Lordships.
You see, let us say, give you again a Hollywood example. Today in the order, instead of Mr. F.U. Borbuya, I write Mr. F.U. Borbuya, I write Mrs. F.U. Borbuya. Let us say we make a mistake. So if you are agreed by that, you will come here and tell us that I am not a Mrs. I am Mr. So therefore, please correct the order.
And
In your case, you have given no explanation at all.
But so far, my understanding and found, Lordships, other contents, Lordships, there are village, area, it was intact, Lordships. Only in this, I admit, Lordships, there are the discrepancies in Tulla, Inu, there are discrepancies. And other side also not challenged. And since Lordship is fixing on 2nd week of February, I will satisfy.
If an evidence is not studying quality, why should somebody make a challenge? Why should somebody cross-examine?
Required, Lordship, since it's a matter of citizenship questions, other family members
Sir, you
are
saying-
not challenged
you're-
also.
You're not, you see, you're not saying about that. You
Yes.
say that you have not been cross-examined. Please tell me if there's no evidence, why should somebody cross-examine?
I stated those are my families,
Yes, he will tell you.
grandfathers,
The problem is that,
and
the problem is that you
uncles,
don't,
and my father.
you don't follow the leading cases. I'll give you a small story. These are somebody was a member of the bar, therefore I'm not saying the name. One of the relatives of the bar member expired in a hospital and medical negligence was alleged. And in the Sessions Court, it would be sometime in 95, 96. I forgot the year. The witnesses came and deposed against the doctors in the hospital. And you know, there's only one question in the cross-examination to the prime witness by another lawyer, senior lawyer who's member of the bar. I'm not saying the name. The only question in the cross-examination was, what was the time of your duty on that day? The witness replied 10 to 5. So no cross-examination. But the incident happened at 8 o'clock. So I was not holding the brief because I had no work. I was sitting in the court, listening to the deliberations which are going on. in the sessions court, and there I learned the art of cross-examination. Only one question. So you don't need to cross-examine so much. You seem towards cross-examining witnesses. Hardly few lines. Okay, we are not disappointing you today, the first day of the working day of the year, 2nd of February. Both sides are
Again.
represented. Well, the records of the tribunal is received. So accordingly, court is inclined to issue rule returnable forthwith without requiring any fresh steps to be taken. This is the matter for hearing in the week commencing 2/2026.
Obliged.
Item 5 for motion.
In this case, not to be shown in the motion column, it's, the LCR is there.
No, this was ordered to be listed in motion column.
Achha.
Notice was not issued. Where is the 2005 voter list?
My lord, 2005 voter list. My lord, by records, it page 24 of the record, 2005 voter list. And in our writ petition, my lord, 2005 voter list,
Is it page
at
36?
page 35, 36. My father's name, my name, and my wife's name is there, my lord. My
Which
lord,
page is the opinion?
an opinion, my lord, lordship will find at page 52. Page 50 starts from page 55. My lord, only point is that whether the learned tribunal was correct in discarding the, my lord, draft chita. It was produced and proved by producing the original, proved in original. The tribunal held that it is not it is not a proper document. Whether the tribunal can say so, my lord, that is the point, my lord, here. Lordship may kindly,
Just a moment. See, so far as draft chita is concerned, we may be against you. The reason is very simple. A draft chita is already only a draft.
no, my lord.
Doesn't
Draft-
create anything.
Draft chita, my lord, there is a judgment of this on court.
Draft chita.
Yes, my lord.
Please enlighten us.
Yes, my lord, in Mujibur Mia case, my lord. Draft chita is a public document. And draft chita, my lord, lordship will know, my lord, it is prepared office, then it is verified in the field, then it is, my lord, termed as a draft chita. My lord, lordship may kindly have a
No,
look at the
because
Mujibur
the-
Mia.
No, because you see, you have experience, you don't want to say it, you don't want to admit it, but you have the experience. After draft chita, it comes to a draft jamabandi. After objections in the jamabandi, then it becomes the perfect jamabandi. So
My lord.
even our draft
My lord, kindly have a look at the judgment of the Mujibur Miya case.
citation, please.
My lord, it is 2025 GLT 395.
Just. 2025,
2020
20,
5 GLT 395.
It talks about draft Sita, it talks about Chita.
My lord, draft Sita. My lord, para 4. Although we are not in agreement for the reasons stated in the said order, but no, on principle, we are of the view that neither the deputy commissioner nor the circle officer or the lat mandal is required to be summoned in a proceeding in the Furnace Tribunal Order 1964 for the purpose of giving evidence as regards the Dabchita, Jamabandi, or the voter list of so. In our view, all the aforesaid documents are public documents of which certificate copy can be obtained by the proceeding. Section 77 of the Evidence Act clearly provides that a certified copy need not be proved if given in evidence. So, my lord, this honorable court has already held that Dabchita is a public document.
মাটিতো আছে না নাই রেকর্ড আছে রেকর্ড তো আছে ব্যাপারটা আছে ইয়ার সার্টিফিকেট কপি তো আছে নাই আমার লগত এটা তো সার্টিফিকেট কপি নয় এটা ফটোকপি কিন্তু কোর্টের পর টার্মিনাল উপর দিছে সার্টিফিকেট এটা আমি অফিসের পর লইছো আর শিল্পে গেছে Mostly like বোঝানো যাচ্ছে
Ms. Verma, we are issuing rule, and insofar as the draft Chita is concerned, that Abdul Mia, this, we are formulating a question to be heard on the admissibility of the draft Chita. But draft, we'll formulate the question, but I'm giving the indication to you. A draft Chita is always prepared in a pencil. And it was never meant to be a document which creates title. A draft Jamabandi is merely a draft, and it culminates into after the settlement operations. Then a draft Jamabandi is prepared when it comes to the settlement operations through the ASO. And if it is mutation otherwise, then it goes to the final Chita, final Jamabandi. But when it comes to the settlement operations, it's only a draft Jamabandi. And after draft Jamabandi, the objections are raised, and then final Jamabandi is entered. So therefore, you see, it's a question of admissibility of the evidence. You bring a certified copy of a draft. Let us say today you have this, what you call, my notes impounded. You file up, you drop up, you are successful in a drawing of a proceeding, and let us say some agency comes and seizes this, my draft. this draft would not indicate the mind of the court in giving the judgment. Let us say in the draft, I say that the argument of Mr. Sikdar appears to be good. This is the draft. I write by pen that I am satisfied with the judgment, with
But-
this judgment
but
cited
one-
by.
I want to say, my lord, if lordship's draft is given in to me in a certified copy, then what will be the consequence, my lord?
It's a draft is a draft.
But given by the
Let us say it is given to
court
you.
authority in a certified copy, then what will be?
It's a part of the record, it is given to you. Now please tell me, will it create a right upon you? When I make the order CAV, when I make this file CAV, will this draft carry any meaning to you? Second thing, if it is a mere draft in the Jamamandi, if it is sorry, in the Chitta, if it is only a draft, will it deter the settlement officer to make an entry of the correct name? Let us say instead of Mr. A.R. Sikdar, they light Mr. A.R. Sirkar in the draft. Draft Chitta. Will it mean that you lose your title? You see, it's with small examples I can make you
My lord,
understand.
my lord,
Draft is merely a draft. So
proceeding,
you can bring a certified copy, prove it, but doesn't prove the title.
but we are
document
not
of-
going to prove the title. We are only showing that we are,
It's okay.
the
we
person is
forget-
available in this part of land.
Forget this, this judgment has to be revisited.
Well,
Issue rule. Mr. A.R. Sikdar, learned counsel for the petitioner and so for the respondents. You said, I'll show them the respondents. Next one. The records of the tribunal is received. Stop. Accordingly, the court is inclined to issue rule returnable forthwith without requiring steps to be taken. Next paragraph. The learned counsel for the petitioner, in course of his submissions, has referred to the observations made by this court in paragraph 4 of the decision of this court in the case of Mazibar, M-A-Z-I-B-A-R, Mia, M-I-A-H versus Union of India and others, within, 2020, within bracket 5, bracket close GLT 395. Post.
civil case में जर्नल लिखिस होगाते civil को district as a लिखिस draft চিটা to freedom মানে ভেরিফিকেশন করার বিষয়ে না হয় ফাইনাল draft চিটা তো এই draft চিটা বলি পাওয়া জাস্ট তো আসেন ফাইল তো আসেন বলো তো আসেন বলো শুরু করি নেক্সট ইয়ারিং আমি আলো রিসার্চ করি
In the
কারেক্ট নাকি
in this regard, with regard to the decision referred to, it is noted that under Rule 56 of the rules under the Land and Revenue Regulation, a draft chitta or a field index is prepared. And after due processing, comma, a draft Jamabandi and record attestations are done under Rule 57 of the Rules under Land and Revenue Regulation. Full stop. The particulars which are contained in the chitta is provided for in Rule 62 of the said rules. Chitta and Jamabandi are in the rules. And therefore, on the next date of listing, the learned counsel for both sides shall address the court as to the relevancy of the entries made in the draft Jamabandi and as to whether a mere production of a certified copy would prove the contents of the draft Jamabandi, the draft chitta, when a final Jamabandi is yet to be prepared with correct entries, with entries made after due correction, after hearing all objections and claims. Next paragraph. This is the matter for hearing in the week commencing 2/2/2026.
Yes, sir.
This is something which we spent some time in the earlier life. There.
Item 6.
হয়তো আমার তাত ফাইল আছে
নাই,
মোৰ তাতেও নাই
টাইম লৈ লওক।
in this case LCR received me but we have a fix for admission
Just go through it.
just no sign on just no sign on
You have to tell us, because what we understand in this case is that the petitioner, after the opinion, was taken into custody.
yes minute
Whether he or she, he is still in custody or is
no
been
minute
deported?
subsequently minute after 2 years as per Supreme Court minute after 2 years he has released minute
Which page is that? Exhibit 3? Brahma, in this case, there are discrepancies in the names. And that apart, what strikes us to this exhibit 3. Exhibit 3 is the voter list of 1917, which is at page 20 of this brief. Now, the evidence is that in 68 the father died. Therefore, the name in 1970 creates a doubt. We have to go through the LCR and assist us. Same second week of the second day of February. Make a note because you always may not remember what you have said. Page 19.
Page 19, I marked it, Lordship.
Both sides are presented, the records of the tribunal is received. Accordingly, the court is inclined to issue no reasonable forfeit without requiring any express steps to be taken. This is the matter for hearing the week commencing 2/2026.
Obliged.
Yeah, next case to 9, Nama. Momirani to 9.
Item 7 for motion.
In this case, Lordship, I pray on behalf of Minister A.S. Bora, Lordship, he is in the midst of a hearing. It will come after some time.
Just a moment. After some time. That's after some time.
Item 8 for motion.
My lord, someone mentioned morning. Actually, I am engaged in this case. P. Rahman is the conducting lawyer. So, my lord, the name of myself and R. Begum may be deleted. Now, Kulatma is there. P. Rahman is there. He is the filing lawyer. Morning, someone mentioned on his behalf. My secretary is there. And P. Rahman is there. He is the filing lawyer. P. Rahman is there. He is. Okay. My lord. But he is not cooperating with me. That is the problem. File is with me. That's the error. My lord,
Don't worry, when we pass orders, we'll give you liberty to litigate and get your fees.
no, no, fees is not a matter, fees is not a matter, my lord, but file is not me, he is not.
But we'll ensure it, don't
Is the
worry.
problem.
We don't want a lawyer to suffer.
Right.
We'll give you that liberty.
Let it come up hearing, I will also, I already informed him. And on his behalf, someone appear and mention morning. But I will also inform him, my lord. Problem is he is not cooperating with me, my lord. My lord, this is all,
In English, we say something which is called hand in glove.
my lord.
If you are not there, you should not have been here. If you are here, then you can't take time that you are not here. Once you appear, that means you have the brief. Otherwise, if the matter is dismissed, how would you be aggrieved?
I have no problem, but petitioner will be suffer. This is the problem.
No, no. Once you involve yourself, that means you are ready for hearing.
Have the brief, please.
Also come time to see the paper office. And then learn it not from the video.
And the tribunal has referred to this at page 39. Since you don't have the brief, I'll just tell you. In page 39, the tribunal says, second paragraph, a perusal of exhibit A appears that a refugee registration survey cannot be relied upon. Page 39. Second paragraph. Now, this is something we are, you have to explain it to us, because this is something why this certificate is not there, merely one line of the tribunal.
Not discussed.
Why?
No reason is.
No reason exactly not.
Why? Now, second is, you will find somewhere when you go down below, in next page, you will find that the Gaubura certificate was discarded because the Gaubura knows the father for only for 7 years. Correct. Now, I have a simple question to you. You perhaps know me from before I was elevated. Mr. Ali may not know me before I was elevated. He knows me for only for 8 years. Will you doubt my credentials? I know him only for 8 years and therefore, who is this man? These are the two reasons the Gambura came, exhibited the certificate, and there are 4 certificates along with the school certificate. School certificate, nobody came. But father's name got connected with the Jambura, and this is again related to Exhibit A. This is something you'll have to answer. Just keep a note of that. I may forget.
Refugee registration and Gambura certificate.
But then the connect is complete. Merely 7 years of knowing by the Gambura or the father may not be a good reason to discard that certificate at all. So both sides are represented. The records of the tribunal is received. Next, accordingly, court is inclined to issue rule returnable forthwith without requiring any fresh steps to be taken. Next, list the matter for hearing in the week commencing 2/2/2026.
Item 9.
Right to sue. Should we add here? No.
My lord.
Right to sue. Should we add here? No. Yes.
The NCR has been received, my lord.
Yes.
We have challenged the order dated 10/9/2018, my lord, by which the petitioner has been declared to move foreigner. my lord.
Page 63.
Yes, my lord. Yes, 51, my lord. Thank you, my lord.
But here the evidence is manufactured.
Yeah.
Your father died
Yes, my lord.
in 1970
And
and he voted in 1997.
1997, after 77, my lord, actually, my lord. Father expired in 1977, my lord.
No. Your uncle deposed 1970. But your father, after his death, voted in 1997.
1997, his name is appearing. my
No,
lord.
we understand. That's why we are asking.
Yes, my lord. But yes, my lord, it's mistake, my lord. Yes. Yes, my lord. How it is possible, my lord? I cannot be hard, my lord. The hearing column, my lord, the matter may be fixed, my lord.
Come to page 57 for evidence.
Yes.
I have never visited any foreign country in my life.
Yes. Yes, my lord. The previous minutes drafted by her advocate. Yes.
You say I'm not a foreign. You say I'm not visited anywhere.
Yes, my lord.
That you are foreigner in the fact.
I have never visited any foreign country in my life. Yes. Yes. Yes, 15 now. 15 now, the deposition of DW2, my lord. There is a mistake, my lord, actually, my lord. It cannot be, my lord. As because my lord, in 1977, my lord, the voter list, my lord, his her father's name has been declared, my lord. Yes. Yes, my lord. No, my lord. Actually, in 1977, my lord, in 1977 voter list, my lord, her father's name is there. You know, how will it, this statement has been made?
Very specific and positive statement. What this will
Is there any mutation order exhibited?
Perhaps, my lord, yes, my lord. Jawab the copy, my lord, exhibit F, my lord.
Exhibit F.
Exhibit
Page.
F. Exhibit F in the opinion, my lord. Now, my lord, which is at page, my lord, 30. Translated copy 32, my lord. 32, my lord.
It's not the order mutation. This is Javandi.
Jawab the copy.
Doesn't have any entry. The date when your name was entered is not there. Relevant entry is at page 33, type copy,
Yes,
second last.
second last.
That doesn't have the date of entry.
So, my lord, as per the order dated 30/4/1992, first by the circle officer of the, and the names of Ajit Ali, son of Zolil, has been mutated
reading
by
where?
virtue of inheritance in the plot of land which is shown. As per the order of the said date, the name of Zainab Begum, daughter of A. Zainal.
For 1992.
Yes, my lord. 30/4/1992.
54, 1992.
Same order. Recommencing second, same.
Commence.
Here also, Ms. Rama, to go through the records.
Yes.
Item 10.
None appears on call for the petitioner. However, all the respondents are represented. Next one. This could, the petitioner had remained unrepresented when the matter was previously called on 19/7/2019. Stop. By an order passed on 19/7/2019. This court had made clear that in the event there is no representation on behalf of the petitioners on the next date, the court would consider recall of the interim protection given to the petitioners. Next one. Accordingly, as the petitioners are unrepresented when the matter has been called, the interim protection granted to the petitioners by order dated 24/5/2019, thereby allowing them to go on bail, is hereby recalled. Next one. However, it is provided that won't make it next para, is same para. Notwithstanding the call of the interim protection, it is further provided that the petitioners shall not be deported out of the country without order of the court. Next para. As the records of the tribunal is received, the court is entitled to issue rule returnable forthwith without requirement of new steps to be taken. Next one is the matter for hearing on 5/2/2026. Make it make it 12 February. This Verma, this could be, there's some issue here. This, last order which you dictated,
Lordship, I recall the interim order.
no, but that's the reason. We recalled it, then suddenly something triggered and I remembered what is the matter about. Now, this is the reference. Correct. Next page is the reference. Yes, after that, after the brown page. Yes, no, your hand, which you are turning. First page, yes, this is the reference.
88.
Yes. The reference is against
Satyendra Chandradi.
Now turn the page. In the, yes, names of family members are there in the first page. Last part. No, in the first page, which you turned. Name of the family members are there and near your hand. Wife, son, daughters.
Not on this.
No, this is the opinion. No, not that. The reference. Ah, yes,
Yes, Lordship.
yes. Correct.
Serial 13, the wife.
Wife and so and so. Now the serial number 1, the reference is against that man. Correct. Now turn over the next page. Last line, the endorsement by the SP sent to the Foreigners Tribunal.
Before 14 minutes.
So that means reference will go only against one. But now reference is registered against all these 5 people. Now something has happened. That's why it triggered us. In the writ petition, in paragraph 7, you have a copy of the writ petition? Oh, just take this. Seven.
He passed away.
He died on
Yes, 2008.
2008. Now, his family members, how can they be arrested now? There's no reference against them.
But have they been arrested, Lordship?
Hmm?
Have they been arrested?
We understand that. But you see the proceedings, we are
Yes.
going to the genesis of the proceedings. Reference is only against one person who's now said to have died. There's no reference against other family members.
And,
So by virtue of that, they couldn't have been arrested.
yes.
So we'll have to allow the writ petition. And if the authorities think that these family members are to be proceeded with,
A
there should be a
separate
fresh inquiry.
Inquiry and separate reference, yes, Lordship.
Because you have not seen the LCR. Now when we saw the LCR, then this will come out.
And they say there's an ex parte proceeding. The
Yes, it's
opinion-
ex parte.
Ex parte. And it's of 88, petitioner died in 2008. So after that, nothing survives here.
Nothing survives here.
Yes, Lordship.
But the plea was a false plea. That the notice was not served. The plea taken in the writ petition
Yes, Lordship.
is that the notice was not served. Now look at the process service report down below in that record. Second last page. Now turn over the page, back page, you see the signature of
Satyendra Reddy.
Satyendra. And in the front page also, that same, this is service report,
This is summoned to the OP. To appear.
someone to be OP.
Yes.
Then the next page, this one. Again, see the back page.
Signed here also.
Yes. So one signature is of the wife, Kumudini,
Kumudini.
and another signature is of that. Now, just before that, third last page is the Hajra given before the tribunal.
And here also there's a
Same signature. I have matched the signature, it appears to be same.
Hmm.
So plea is false.
I understand. Since Lordship, nobody has been representing them, Lordship may point a amicus and pick up this matter, Lordship.
No, but decided because since you have seen that and is already expired, it's not there.
It's not very Lordship.
We don't need an amicus for this.
We'll assist lordship.
Check out that earlier order. None appears on call for the petitioner. Puspa. Next, heard so for the respondents. Next one. Filing this writ petition under Article 226 of the Constitution of India, the petitioners, namely so and so, age 3 and 4, 4 petitioners, have assailed the ex parte opinion dated 15/7/1988, passed by the learned member of Ordnance Tribunal, Diffu, in FT case number 394/87, arising out of reference police case number 394/87. Post of the learned tribunal held that the notice was duly served upon the proceedee and as the proceedings was not contested, the proceedees were declared to be a foreigner or foreigner under section 2 within bracket A of the Foreigners Act of 1946, read with section 3 to 6 within bracket A of the Citizenship Act of 1955, holding that their migration was in between 1/1/1966 and 24/3/1971. Next one. The learned standing counsel for the FTN Border Matters has submitted that not only the proceedings against the petitioners was ex parte, but even before this court, the petitioners were absent on 19/7/2019, when the matter was previously listed, and they are also absent on call today. It has also been submitted that by order dated 19/7/2019, it was made clear that if there was no representation on behalf of the petitioners on the next date, the court would consider recall of the interim protection given to the petitioners, which is by way of bail granted to the petitioners by order dated 24/5/2019. Next one. On a perusal of the materials available on record, the tribunal's records, it is notice that the inquiry by the inquiry officer was directed against one Satyendra, Satyandra, Satyendra Chandra De, son of late Upendra Chandra De, whose names and particulars are entered at serial number 1 and 2 of the form. Stop. In against paragraph 13 of the said form, the said interrogation report, comma, the names and addresses of the names of the other family members being Srimati Kumudini Bala De within bracket wife, Somiron De within bracket son, Safan De within bracket son, Ramu De within bracket son, and Sayal De, Sayal De within bracket son. Shamal De, make it Shamal, Shyam, Shamal De is mentioned. Stop. The endorsement by the sub-inspector within bracket border is that the person came into India without any valid documents. And so he may be treated as foreigners of 1966-71. Accordingly, the Superintendent of Police, Karbi Angalam District, Dipu, referred the matter to the Foreigners Tribunal, Dipu for opinion. Stop. However, as per the tribunal's records, the notices were issued to the proceedings, which includes the petitioners and their father. The notice was duly served on the mother of the petitioners, on which appears at the back page of page 13 of the TCR, which bears the signature of Kumudini De. And notice was also served on Satyendra Chandra De, which appears from his signature, appearing in the back page of the summons, available at page 15 of the TCR. Stop. That apart, in the attendance sheet filed by Satyendra De before the Foreigners Tribunal, Dipu, on 5/1/88, the said court attendance bears the signature of Sri Satyendra De. Stop. Next page. Therefore, there is no doubt that notice of the proceedings were duly served on Satyendra Day. Next, however, the reference appears to have been made only against Satyendra Day and not against the present petitioners. Next one. You also notice from statements made in paragraph 7 of the writ petition that Satyendra Chandra Day had died on 23/8/2008. Next one. In view of as the inquiry was directed against the Satyendra Chandra Day, was stated to have expired on 23/8/2008. The said ex parte opinion, the impugned ex parte opinion dated 15/7/1988 would only be could only have been answered against the said proceeding and not against the present court petitioners. Next one. Resultantly, insofar as the challenge to the impugned opinion dated 15/7/1988 is concerned, court is inclined to hold that the said opinion would only be enforced against late Satyendra Chandra Day, the father of the present petitioners. And not against the present petitioners, namely so and so. Next one. However, court is further inclined to provide that this order shall not come in the way of the Superintendent of Police within the order, Scarby and Long, to cause inquiry against the petitioners, if so advised, and to take appropriate steps. Not advised here, and take appropriate steps as it is so advised. Next one. The petition says dismissed. No, the stands answered accordingly. Next para, the records of the tribunal be sent back expeditiously. Next para, the learned planning council for the home and FT matters shall transmit a download copy of the order to the concerned authorities. This stands disposed of.
Order communicate.
Party allowed to the extent as indicated.
SP को करना पड़ेगा. Council district का.
Item 11.
None. Appraisal call for the petitioner. However, all the respondents are represented. As the records of the tribunal is received, court is inclined to issue rule returnable forthwith without preparing any extra steps to be taken. Next, it is made clear that if the petitioner remains absent on call at the time of hearing, adverse orders may follow. Next part. This is the matter for hearing in the week commencing 9/2/2026. Well written order. The tribunal has in fact, there's a very decent way to decide this. I don't know what would be the expert term, but a very decent way of discarding the evidence.
May I please, Lordship? Lordship, impugn order at page 49, 25 to 2019, LCR was called for. Page number 49, annexure 13. Before the tribunal, my lord, petitioner exhibited migration certificate, that is 1965, as well as certificate of registration of his father, my lord,
You would have to show from that document
my lord.
that this is something which can be deciphered. We can understand what is there.
Yes,
The name of the authority is not there.
yes. But in the last, it is bottom portion, it is authority is showing there that ADC of Durham. So I
Have
have
you seen your evidence?
my lord.
Have you seen your evidence?
Yes, my lord.
You
This-
come to paragraph 4 of your evidence.
My lord, here my written statement is there, evidence is,
Your evidence.
my lord.
You said that you have proved that.
Evidence also.
Read your evidence, paragraph 4.
Written statement. My lord, with me, evidence is not annexed here. 30. It will go. It was a Shamal, move to my. With
So
Shamal,
anything that is relevant is not with you. Okay.
yes.
We'll
Written
give you,
written statement is there.
we'll give you the ECR, page 28. Paragraph 4 was the next page. You have not said who's the authority, so even you don't know.
My lord. My lord, can you join in, there is a mismatch, in judgment. It is saying that, exhibit B is the certificate of registration, but here it is, my lord, migration certificate. So, learned tribunal has said that in the certificate of registration, there is no authority.
Correct.
But in the migration certificate, it has not been mentioned in the judgment, my lord, in the
Where
order.
is your migration certificate?
My
Which
lord,
document? Which page?
migration certificate I have annexed, it is, page 13, my lord, kind of find. Page 13. It is issued at the checkpoint of Gitaldaho.
That I won't be able to say because your evidence is there, which I have already sent back. I have not, I can't remember it properly. If you see that page 28, is migration certificate exhibited? You don't know?
Yes, it is.
Yes, exhibit A is certificate to 56 migration certificate. This exhibit migration certificate as per evidence it was.
Exhibit
A. But,
A.
yes, madam. But in the final order, exhibit A is the school certificate. There is a
Send
message
it back, send it back. I did not see it.
But it says it could not be produced.
it was produced, but a mismatch here in the final order also, that exhibit A is school certificate. But as per my evidence, exhibit A is migration.
No, no. It is not. That's why we send you this record.
Page 50, my lord, in the final order.
Problem is that you see, I spend my time telling you to look at the LCR.
My lord.
You don't have time. You are a busy man. You don't have time. The reading of the LCR is only the business of the court. Why should you read it? You will only find fault. See page 37. So see, I don't have a very sharp memory. I won't remember which page is that. For that, we had to take the LCR. And you all don't have time. You have page 32, exhibited document, exhibit A. If you don't know how to handle a trial court record, you shouldn't make comments that this is wrong.
My lord. Exhibit A here it is.
If I have 30 matters on board, I can read the trial court record. You have only one brief and you don't read it.
Right. So my lord, in this case, then exhibit B is the certificate of registration.
So if you have not proved it, what is there in your case?
So in the certificate of registration, there is no authority there.
Then
But in the bottom portion, it is authority is mentioned.
it's not proved.
Bottom portion, it is mentioned that the ADC.
You see, we have shown you the evidence. Where is the relevant statement?
My lord. I have stated in my written, my pleading, my lord, that authority was mentioned in exhibit B, but
You see, Mr. Das,
my lord.
we at times, not to these members of the foreigners tribunal, but we spend some time at some place somewhere deliberating on the nature of pleadings and evidence to the judicial officers. In none of my sessions, before any, before the, in the meeting with the lawyers, in meeting with the judicial officers, I have given them a training that, look, evidence will come, evidence will be lacking in 100 things. So you'll have to look in the pleadings, you'll have to look into the document, find out what is left out in the evidence, and then give a judgment. Now, please tell me, to show that I am wrong in my presentation before the judicial officers and lawyers, show me any authority which says so, that after the evidence, look into the pleadings, look into the documents, find out which is not pleaded in the evidence, and then read it. Show me one authority. High Court, Supreme Court, or even the district judge level, any judgment which says that the evidence should not be looked into alone, you'll have to read the document and find out and then write a judgment. Any authority on the point? Don't go to Supreme Court, don't go to High Court. Tell us even the district judge court. You see, you are an officer of the court. Please make responsible statements.
No.
You are teaching us the new law of evidence. And that also you are making a comment without knowing what is there on record. Reading now will not do anything.
My lord.
You have failed to prove anything. You show us from anything that there is
My lord.
wrong.
I may pray for some time so that I go
No,
through.
no, not after all this.
My lord.
You make irresponsible comments and then when you find you are unable to come out of it, Then you frame for an adjournment. That's why we asked you only one question. Out of all these exhibited documents, we have asked you only for one document.
But my lord, my humble submission that saying that document was not produced, it is exhibited, my lord. So authority, it is disputed in the top portion, there is no authority.
But who has exhibited the documents? Is it not the duty of the lawyers to produce the evidence and then the court will sign it?
My lord.
Has that not been followed in this case? This exhibit ABCD marking was done by the tribunal, dehorsed the documents, dehorsed presentation.
My lord, I shall produce the original,
I am not the trial court.
my lord.
I am not the foreigners tribunal. Neither both of us. When I say I, we mean both of us. We are not foreigners tribunals. You look into the original documents. We have shown you the document. We have shown you the evidence. The evidence was not with you. We gave you the records. Still, you don't have time to read into it. How many times in this bench we have said, please consult the TCR before you start your open your arguments. How many times? Every day I may give a unnecessary lecture. Not a single day passes when I don't say this, that please go through the trial court record and then address this. And Mr. Das, not only I say it in the court, I also follow it up. I am aware, as on today, till now, how many of you have seen the LCR? I am aware of it.
I admit, my lord, I have not seen the LCR.
We know it. That's why we ask you only one question.
I'm sorry, my lord, next from today onwards, my lord, I will not do it.
When you take a brief of a trial, which leads to a, which is of the trial court, and you don't look at the LCR, that is the worst disservice you can give to your client. How can somebody say in appeal that I have not looked at the LCR and I have started my argument? You must be truthful in what you are doing. You are holding a brief. If you're not truthful when you're holding a brief, please leave it. Neither you are giving service to your client, nor you are giving service to the court. You're not assisting the court.
My lord, as per record, it is.
And when we pass an order saying that we are holding the opinion, then you will say that the court has not heard you. The court has, the allegations made in the writ petition is that the court has acted mechanically. It's so easy to accuse someone acting mechanically. When you ask the question, you don't know about it. When you don't read your brief when you are in court, you should do that in homework. As a part of homework, you should read the brief and then come. This is not the place where you read your brief. Mr. S.C. Das, the counsel for the petitioner, is ill prepared with the brief. Therefore, prays for an adjournment. Prayer is allowed. All the respondents are represented. List on 7 January 2026.
Item 13.
May I please? My lord, trial court record has, my lord, received, my lord. Page, my lord, 114. My lord. Yes, my lord, lordship will find operative part at page 123. My lord. Now. But my lord. But father's evidence, that was not properly not appreciated. Now, once father says he is my daughter or he is my son. Well, well, I'll search it. Well, But in this case, my lord, it will some impact because she will inherit the property of his father. I'll go through. I'll go through.
Without requiring any fresh steps to be taken. Here's the matter for hearing in the week commencing. 2. Nine to, okay, 9/2/2026.
Developers.
Item 14.
May I please, Lord?
Yes,
My lord, the LCR has received, my lord,
which page?
and opinion, my lord, page 62, my lord.
60.
2.
Where is this Jamabandi? Which
The-
page?
Jamabandi, my lord. Page 27, my lord.
7.
certified copy, my lord. Yes. Is 31, my lord, serial number 9. Then petitioner's name, serial number 22. Is 32.
You see, it says represented. The records of the tribunal is received. So accordingly, the court is inclined to issue the returnable with without requiring any steps to be taken. Next, list the matter for hearing, the week commencing 9/2/2026. Mr. Sharma, you'll have to see this, just make a note, you have to see this LCR when you make your submissions on the next date.
Yes, sir.
Here you will have to go through the LC.
Item 15.
Just, Mr. Saria, you are waiting for which item? 16. 16 will take it up. We don't want you to wait. Item 16. Small matter.
This application was filed challenging an ex parte order passed by the Apti Court at Sagar at Jorhat.
Lordship. Boxes. Wrong file has come out. Actually, Lordship, earlier a deputar case was filed, Lordship. That
So original file is. I am challenging this order.
Lordship. Yes, yes.
Yes,
Lordship.
service was not there because London trial court. Inida has stated the fact. अपने page 28 20 हमारे पास ले
11.
yes.
Just let him look into the records. Sometime.
আৰু প্ৰচেছ চাৰ্ভাৰ ৰিপৰ্ট
Item 15.
শিৱসাগৰতে কৰিছে কৰি পেলাই দিয়া আছে তালৈ কিছুমান শিৱসাগৰ এডমিনিষ্ট্ৰেশ্যন চাৰ্জ কৰা দেখুৱাইছে procedure is complete সেইকাৰণে চিভিল জাজে কৈছে মইতো মানি বেছি চিভিল জাজ advocacy to you.
Yes.
May I please your lordship? Lordship, opinion is at page number 26, lordship, 27, lordship.
27.
27, page number 27. Order dated 24/01/2019.
Your brother came as DW2.
Yes.
You forgot to mention him in your written statement. You forgot that there was a brother in your written statement.
Cousin brother, lordship.
What is that? The records of the fabulous receipt, what is in fact the use the number of copies without requiring any first steps to be taken. This is the matter for hearing. The week commencing 9/2/2026.
Deeply obliged.
We don't want to pass any adverse orders. They're getting the benefit of first day of the year.
Yes, lordship. Obliged.
We will change our character tomorrow.
No, let's continue. Let this continue for the whole year.
No, Mr. Salia, you see, all good people say, including you, that all good things must come to an end.
No, good things should not come to an end. It should always be good. Salman?
Obliged.
Give me the copy.
Item 17.
May I please your lordship? Worship, let the matter after tomorrow, my lord. Today, my senior out of station only.
No. Yes, Lord. कितने बुला के लेके गया कौन सा केस
Item 18 for motion.
Opinion order is at 19. My lord, 1 minute. My lord. There is a communication gap within various manner. Could not obtain the certificate copy in time, my lord. The irritated person, my lord. Yes, my lord. The one we do. Madam, 18 my lord. 18 variety. My lord. It is 43-0. Mindful. Obliged.
Item 16.
There was earlier a decoder case, meaning that no such reference will against the proceeding and earlier petitioner filed a decoder case, lordship, in single bench, lordship, and after that it was I yes, lordship, as per my submission, lordship, a notice was duly served as per 35F, lordship. And lordship will kindly see the page 18, lordship. This was proceeding to.
This speaks of the case that was there in the Zorat tribunal. And your lordship may go to page 33. Page 33 of the Learned Singh Judge's order, where in the voter case. Page 33. It is clearly stated there.
Last para, lordship. It is to be mentioned here that. Yes, lordship. Now the challenge has been made by yes, lordship, because process server report is not here, lordship, in the repetition. Yes, lordship.
No, order clearly states, Milord, because there, in this case, Milord, the original address was also there. But the Learned Tribunal has stated lordship can go to page 33 also of the Learned Singh Judge's order. Eleven.
11.
No, Milord, but I'm a local resident of Dhubri.
Sir.
Soraidu. This should be SP Soraidu, madam. The record is at the SP Soraidu. Yes, Soraidu, within the tribunal has the jurisdiction. Soraidu, Sipsagar and Golaghat in Jordan. Yes.
That's true. That's true. I'll file an application.
Item 3, fixed at 2 p.m.
Thank you. Yes, I, sorry. The district judgment. Para 21. Yes, this is on certified copies. Para 2120. 8. Yes.
21.8, 21.7. It says whatever your lordships indicated. 21.7.
That is.
Heard Mr. D.P. Bora, our counsel for the petitioner, and solicitor for the respondents. The plan model dated 2/12/2019, comma, this court deemed it appropriate to call for the LCR before passing any orders in the case. So accordingly, notice of motion was not issued in the matter. Next para. The records of the tribunal is received, and as the matter pertains to the year 2019, this writ petition having been filed on 4/4/2019, with consent of all sides, the matter has been heard. After issuance of notice of motion, issuance of rule returnable forthwith without requiring any steps to be taken. Next. list on 9/1/2026 for delivery of orders.
Fine one in operation.
Print out. We need to print out. It was great.
Time being item 7.
Okay. Okay. Yes.
I'm saying the opinion print page number 43, it is dated 28/2018. Then. So in the tribunal has declared that his the opinion that it is from the post 1971 period, my lord. Here, my lord,
But apart from your voters list, what else document do you have to connect you to your parents?
yes, my lord. Lordship will straight away go to that DW2. And she happens to be the mother of the OCD, my lord. And he is 85 years. She deposed before the tribunal also that she is the daughter. And in the cross, my lord, Lordship will find it page number 38.
Which is the deposition page number?
This is the cross mark, page 38, my lord. Specific on the part. She said that the proceeding, her name is Khataman Nasa. I am also known as Sona Khatum. I have both my names in my document. My son and family members of the family not submitted the application before the election office for concern. Facts of my name. The petitioner, Mariam Nasa, is my own daughter out of the 6 sons who has already died. She has
Where is
deposed
the voters list of 2005?
2005, my lord. 2005. 2005, Lordship will find it page number 28, where her name has entered as a Sona Khatun, and he is and the
There's a change of identity.
change of identity, my lord. He has already in the WS, both the procedure and the W2 has stated that there is a wrongly, your name has been wrongly entered in the voter list in 2000. Earlier it was correct, my lord. In 2019, 89 and 2005, it is wrongly written, my lord. But you will find that 1989 called voter list in page 26.
There's a process of correcting it.
There's a process of, he has admitted that that process has not been undertaken, my lord. That process has not been undertaken.
You designed Basidon BV.
Yes, ma'am. 2018 1 GLT 374.
I'll examine, my lord. Lot will proceed in any other day, my lord. 374.
374.
It is 19 January. As a presenting fair make around this from 19/1/26.
Lots. Lovely, Lord.
Okay, we just say that. Which is presented, as the records of the tribunal is received, what is inclined to issue notice of motion returnable on 19/1/2026. Accordingly, is the matter in the admission form on 19/1/2026.
Upgraded item 36 for orders.
I think is for the applicant.
For the applicant. My learning is for the applicant. I am for the applicant. So Kukan is possibly from. For the applicant, for the applicant. For the applicant. Applicant of the respondent. Respondent in the AP.
It's the eighth one, item 36. Okay, just wait for some time.
My learning.
What is this IA for?
For modification of the interim order.
Yeah, what is the interim order?
Interim order. Stay of the judgment passed by the own single judge. Some people are suffering, man, I am told, some people are suffering because of the.
We respondents are suffering. I am responding number 41. I am a doctor, having my nursing home at Maligaon. And I want to extend my nursing home for establishment of Cancer Institute, Heart Institute, but for the interim order, I could not do it.
I'm actually on this side because I'm one of the applicants, Lord.
No problem.
And my IA has been listed. I'm responding for 65 actually.
This is with regard to that, Kamakya land.
My lord.
What has happened? Has the land record been placed out?
Yes, lordship, if you kindly see the judgment, the authority part.
No, you see, since I read, since the issue of Kamakya land has come up, I am recollecting something which occurred in the hearing at one point of time about 6 years back.
My lord is right. My lord, my lord, that order actually I had enclosed with my application.
Now, what happened was,
My lord.
I'm recollecting the memory of about 6 years back. I may be horribly wrong.
Lordship is correct.
But what happened was, a report had come to the effect that the original rank records were sent to this court through the office of the senior government advocate. And after that, they say that those were not returned. And there is a report by the deputy commissioner saying that the land records are lost. Now, that was the backdrop. After which we passed certain orders, and thereafter I was not in session of the matter. Therefore, I have lost a track. But the primary question before we examine anything in this interlocutory application would be whether the land records are available. Because what had happened was that the transfer of land were all stayed because of operation of the orders of this court. And this has continued for more than 10 years now. I may be wrong in the years.
2003, the original order was passed.
Three. Okay, I am wrong there. So from 2003 till now, no effort has been made by the state to reconstitute the records. Now, this is where I lost track. What happens to the land records? How the director of land records have assisted the state for the purpose of reconstruction, that is something I have missed out.
If your lordship permits me, possibly, my lord, subject to correction, that issue will have relevance so far as the interim order of passed earlier is concerned and the persons affected by that is concerned. But ultimately, the final judgment, if your lordship kindly goes to page 294, the directions were possibly on the merit of the case in this way, my lord. Page 294.
Please 294.
294. Page 294, paragraph 12, at the bottom.
Now here, this is the problem. Before that,
Madam.
I'll show you something.
Madam.
The bench which I was holding, I don't think this was the matter. Some other matter, but related to Kamakya land.
There is
And
another issue.
Somebody from Delhi came and argued the matter. I forgot who.
I had appeared, my lord.
You had appeared.
Because what had happened, my lord, in that particular writ petition, I was one of the impeded respondents.
I don't recall you, somebody else from Delhi.
But I had also appeared, my lord, that order also I have enclosed with my eye, which your lordship will find at page 92.
No, I am not on that, but I'm just, since I am, memory is failing, that's why I'm just trying to recapitulate because Then I would understand the context in which those deliberations took place.
When my matter had come up, my lord had referred to that matter, that your lordships were aware that the files were not traceable. And your lordships recollecting that, my lord, your lordships had passed this order, which your lordship will find at page 92.
Okay, just
Was the-
for a moment,
It
page
is-
291, where the,
But possibly that is in that case.
no, maybe I just,
Well,
I told you, my memory is
Yes,
failing.
yes. Otherwise, issue is in respect of the Kamakya temple.
Kamakya temple land.
That
But
is,
come to page 291.
my lord. Ma'am.
Oh, sorry, not 291, it's 290.
Yes.
Yes. Now read this paragraph 8.
My lord. Section 40 of the Assam Land and Revenue Regulation 1886 provides for framing of records of right of estates. Such records of rights is the Jamabandi based on the Chitha and the field map. It is to be done in a prescribed manner. The procedure prescribed is that entries in the record of right are to be found on the basis of actual possession. At the time of settlement of operation, the Jamabandi is prepared which records the names of settlement holders on the basis of possession. The allegation of the petitioner that no Jamabandi was prepared and a duplicate copy was only there without any signature has been refuted by the state, and the state contended that the Jamabandi of Kamakya village was not prepared in the year 1973. Rather, records of right of Kamakya village was prepared in the year 1957 to 1964. And 2 copies of Jamabandi were prepared, one for the use of the Sadar Jamabandi and other was used as working copy in the concerned revenue circle. In absence of any material to show that these statements are incorrect, this court cannot hold that Jamabandi was prepared in the year 1973, as alleged by the petitioner. Further, the challenge to such creation of records of right is on the ground that the Jamabandi has been prepared without demarcation of the retainable land. Such determination cannot be entertained by this court at this stage, as discussed here and above. Therefore, the contention of the learned counsel for the petitioner that the original Jamabandi and duplicate copy are liable to be declared as null and void is negated. It is slightly, context is slightly different. Here, my lord.
We understand, but now this is the question now comes.
Yes.
That if the land records are lost,
My lord.
if that situation still exists, in that case,
My lord.
how will you term something as original and something as duplicate?
My lord, so far as this case is concerned, again, I'm saying subject to correction. That issue may not be relevant because your lordship will kindly see. First, I'll point out the directions given, my lord.
Yes.
My lordship will kindly turn to page 294. My humble submission will be the issue here is slightly different. Their prayer was different in the petition, and
Yes.
therefore the subject matter itself is slightly different. Page 294, my lord, para 12. For the reasons and determinations made herein above, this present petition is disposed of with the following directions. The prayer for declaration that the resettlement operation carried out in Kamakya Hills and Nilachal Hills on the basis of original Jamabandi, a Jamabandi of Kamakya village of the Nilachal Hill, alleged to be prepared in the year 1973 and duplicate register is null and void, is rejected. So this prayer that the record should be declared as null and void is rejected. This is number 1. Number 2, my lord, this is very important. The Deputy Commissioner Kamrup Metro to verify the already determined retainable area. Well, here we are concerned with the retainable area.
In that case was also the retainable area an issue.
In that
What? Yes, that now I recollect. Once you say this
My-
word, this
Retainable area.
retainable area,
Yes.
then I will not recollect what has happened. The matter which I was hearing
My lord.
at that point of time, the issue involved was the petitioner was represented by Mr. D.K. Mishra. He raised an issue with regard to that the Kamakya Devala land which was acquired was under the what do you call this what do you call religious act religious
Yes, 56 Act, my lord.
yes act
Of 59.
now yes that contains a provision which says that the retainable area will be determined.
Yes, my lord. Yes.
And then the issue was that how could it have been determined because the original records were lost. And in that context, it came out that there is a records of the Deputy Commissioner which shows that the original records were sent to this court and thereafter lost. So it is at that stage
Your lordship lost it.
After that, I lost track, but when this retainable area comes again, I have now recollected in what context I was hearing the matter.
My lord.
So now you see what has happened.
My lord.
Please see that section, 59 Act.
Yes.
It is at which page of this book?
I'm just section 5 of Act play. And it's like Assam State Acquisition of Lands Belonging to. তো কালী জাতি পুরুষ লিখিত আমাদের তুমি জানো
What is the name of the act?
The name of the act is actually Assam State Acquisition of Lands Belonging to Religious or Charitable Institutions, 1959. Section 5 is relevant, your lordship.
Yes, that is 756 in this book.
Yes.
Second last, 49, serial number 49 in the index.
Section 5, yeah. Section 5. Yes. Section. Yes. Power to retain possession of land after acquisition. Notwithstanding, may I read my section 5?
Yes.
Notwithstanding anything contained in subsection 1 of section 3 and subsection 1 of section 4, a religious or charitable institution, including its individual branches, if any, shall, with effect from the date of vesting, be entitled to retain possession of, free of revenue, all such lands which on or before the last day of Chaitra 1365 BS were in the ownership of the institution and were actually occupied by it by constructing buildings and raising orchards and flower gardens together with compounds appertinent thereto, and all lands reserved for the resident devotees for residential purposes, provided the right of ownership or possession of such land shall not be transferable or alienable. Tea garden land, provided such land shall be liable full revenue rate under any existing law.
Yes, now you see,
My lord.
now you see the Chaitra 1365.
My lord.
Equivalent would be about March 1959.
Yes.
Correct.
My lord.
So the position of the land with the Devalaya on that day
My lord.
is not known.
Well, there is a question. My lord. In fact, in this case, almost some single judge has come up with a finding that, see, unless we know what is there existing, today's position is such, and this writ petition was filed after so many years, my lord. That was also taken into consideration. This was a writ petition filed in 2003, whereas this vesting of land by virtue of this act was in 1959.
That's
Now
why we are trying to understand. In that case also the same thing happened. Now you see, just using the Assamese language. You see, earlier when there was 1959, when there was land holding,
my lord,
you may have a land. I'm not presuming you are born before 1959. I'm just
after that.
So supposing you have a land of 1959.
Not very long, after some time.
No, that's why I'm saying, in a lighter note, I'm saying. So if you had a land, you said that land and then bari.
Bari, yes.
Now we have no definition of that bari because at that point of time, people used to know the next door neighbor.
Yeah.
And they would know that his land is from here to there.
Yes.
Correct. Some mango tree somewhere, they will say that that is up to that is my bari. Now when this enumeration started, that means that there must be a settlement process initiated. Settlement process was not in 1973. If you tell through a settlement process, then 63, 64 would be relevant. I'm not aware, but you'll be knowing more because since you are the authority of the state. 73, I don't believe there was a resettlement process in Guwahati.
57 to 64.
57 to 64.
Looking 64 years.
Correct. So therefore, first of all, this declaration given must be of some, must have some basis to arrive at a finding that 1973 was incorrect. That is why it overlaps the issue which we heard earlier.
Right.
That if you don't have a land record, if you don't have a settlement record, then to claim that this land belongs to Devalaya or not,
Yes.
was the issue which came out in that first writ petition which we were hearing of Mr. D.K. Mishra. Trying to retain the land, saying that this was a Devalaya land, because earlier, you see, first of all, it was a Devalaya land.
My lord.
Devalaya land was allowed to be held
My lord.
by the Sebayats
Yes.
or Purohits or the priests, by whatever name you call them. They were allowed to retain that plot of land. But in essence, the land belonged to the Devalaya. That character was never lost. So once this section 5 comes,
Yes.
please read again.
Yes.
We are in ownership of the institution and were actually occupied by it.
Yes.
Now please tell
By
me,
constructing buildings and raising orchards and rubber gardens together with compounds.
in Devalaya, there was no compound. I can assure you, there was no
Maybe.
compound anywhere.
Yes, ma'am. This provision is there for some other
Because then if you say the
land.
compound, then the Devalaya compound would be
My lord.
just in the vicinity of the temple where you have this
Wall.
half wall of 2 feet, 3
Yes.
feet now.
Yes.
Apart from that, there would be no land for the Devalaya. And in occupancy. Now, the deity would not be sleeping over the land with hand covers saying that this is the possession I
Yes,
am
yes.
having.
Yes.
So it must be symbolic possession.
Symbolic.
These are the things where we missed last time. If you see the answer, if he's correct,
My lord.
73 was not the settlement period, then you need to show us that this settlement period culminated in the drawing up of a Java Mandir in the year 1973.
The next direction may kindly be seen for a moment.
Yes.
Page 295, Roman 2. The Deputy Commissioner Kamrup Metro to verify the already determined retainable area belonging to the deity of Sri Ma Kamakhya under the Act 1959. And that if it is found that retainable areas earmarked are under encroachment, the Deputy Commissioner shall evict those encroachers from the retainable area by following due process of law and hand over such land to the petitioner number 2.
That is why the land records are missing.
My lord. In fact, my lord, before this order was finally passed, I think affidavit was filed on behalf of the Deputy Commissioner. From this Deputy Commissioner side, my lord, voluntarily it was said that if this kind of direction is given, we are ready to verify.
No, but you see,
My lord.
first of all, that's why, you see, since I lost track at a point of time, I am still there.
My lord, you
I am
are
going back in time. I am trying to find out whether the land records were there or not.
my
So
lord.
you want a specific answer from the state, whether you have the land records or you don't have. You see, now the question of when it comes to verification,
My lord.
how do you verify? You must have a base document and then
Exactly.
start a verification.
Otherwise,
If that base document is not there, how do you propose to reconstruct that?
my lord.
That's why
In fact, my lord, I'm aware because
what you call the gramophone age, where the pin stuck
Pin,
at a place and then
suddenly it starts
No,
from the middle of the song.
it gets stuck there only.
And the same thing is again and
Same thing
again.
again repeated.
Gramophone days. And in this case also, possibly, I appear before the one signature also, I think. Now the records.
Whether you have the records, you don't have the records. As it's the only question we're asking right now.
My lord, possibly the records were lost. This was the version even in this case also. At one point of time, I am
But
aware.
according to the state, how do you propose to comply with this?
Direction number two.
Direction number two.
That, my lord, because the affidavit has been filed saying that if this kind of action is given, we are ready and we can verify. I'll have to find out how they will do it.
We need to 2 times.
My,
Number one, you just go there, look.
yes,
Verify.
That's not a real
Second is, second verification, as per the land records, is that small 1 1/4 inch scale.
And that is the real verification.
That is real verification. How do you supposed to do it? Because you see, Mr. Mazumdar, since you know the land laws, I don't have to tell you much. Under the land and revenue regulation, when you do a verification, if somebody is in occupation, you have to leave that land. 23 or something, I forgot. Is it 23? Land and revenue regulation?
Maybe.
Huh, 23.
23. That's in case of boundary, yes.
Yes.
There is about boundary dispute.
Huh. So this is on the basis of actual position.
Actual position.
Now, let us presume something.
My
A is the owner of the land.
lord.
B is found in possession. Now, the revenue authorities do not have the power to make an inquiry about the nature of possession it is having.
No.
He may be your staff residing in a quarter provided by you. He comes up and says that his staff comes and says that I am in occupation of this room. So he is found in actual possession, and therefore this area is excluded. This is what I understand from 23.
During settlement, my lord.
During settlement period. Now, if you have a base.
Because
document,
settlement provisions itself very clearly say, based on possession only, they will settle.
they will settle it.
Right.
Now, therefore, we need to have, once you say Chaitra 1365,
Yes,
relates to March 1959.
59.
Now, you have to tell us how you assess the position.
And that is why possibly this issue came up in this case.
If the government has a will, it will find a way. So that is why in this land, there is a lot of encroachments. There are many
Yes, yes.
multiple, what you call, proceedings where people can't come to court. But the land documents, the land records are not there, transfers can't be made. If you are declared to be the owner of the land, then you must have the right to transfer. And if you have a right over the land, then you can make any construction. Why the construction should be stopped?
That is the context in which I have moved my IAM, because I'm not able to make any use of my land by purchasing it after paying all requisite stamp duty, after obtaining no objection from GMDA. But I have not been able to make any use whatsoever of the land.
You see, everything is, we told you this. See. Yes.
Yes.
Please tell me how the land is in permission to be granted. Because why this whole economic was released from the. You're still not aware. Is the land of the very top line.
I completely understand. The learned single judge, while disposing of the writ petition, relied upon an affidavit filed by the state where they said that the retainable area is known to them and they are willing to demarcate the land and also evict encroachers. That record whether that only the state can. Look, but apart from that issue, my lord, apart from the retainable area and the state's own admission that they are aware of the retainable area, the learned single judge also rejected the writ petition on two grounds, my lord. One was on delay and latches, second is on disputed questions of fact. My lord. That there are too many disputed questions of fact involved, which the writ court cannot go into. They do not have any substantial ground in their writ appeal to show, my lord, how the writ court can actually go into these issues. So those issues, my lord, the
The writ appeal, Lordship. Contentions in writ appeal, Your Lordship.
Yes, ma'am. Just very relevant.
Yes.
The page.
No. The office of
Yes, that case. Yes. And prayer is at page 111, 111.
Wait.
No, it's all. Issues are otherwise related matter. There is no gainsaying. No, not at all. No. Page 112, also kindly see. Call for the records and pertaining to the preparation of the original Jamabandi in 1973 and the duplicate register in 1987 and the chithas along with such original Jamabandi and duplicate register and the chithas and the records pertaining to the current resettlement operation which is in progress, issue a rule calling upon the respondents to show cause as to why the original Jamabandi and duplicate register and current resettlement operation along with all steps in furtherance thereof already undertaken by respondent number 3 be not declared as null and void and illegal in view of the non-demarcation of the retainable areas. This is the first pair. This issue is connected, your lordship is right. And be further pleased to issue rule in the nature of mandamus calling for the respondent number 3, calling upon respondent number 3 to refrain from processing any further with the resettlement operation. My lord. My lord. Yes, ma'am.
This would be
Yes, ma'am. Yes. Only.
No, but my land seems to be in another hill, Shruda Sarovar.
Irrespective of that, this different. You can be in any village. You cover everything. You can go to any expedition to because land is we got another.
I purchased the land miller from a registered pattidar. That is.
When you say that this is the this I. You think from other stand when and if you see all the, if you look at that all the now, all the land is never the word is
There was
Okay. Lakhiras land, your lordship.
Therefore, this is not now land of the now, when they get issue of attack, they will be in settlement of some kind of thing to land. In 1959, this land was required. Whether it was required, question of land, or it was land, how did the land work? Because the enter to this I know saying
Not clear at least. Yes, this is not clear.
therefore, I issue. But my intention was to say that I need some says.
But the fact remains that nobody has come forward to dispute title of my land.
This feels.
Right.
Saying because it was told by the ADC, saying that the land was very few people also there. We did not. But from the office, the found by the government then.
Yes.
Was that it was produced before the war. Now, in our record, this the order record with Balboa.
Right.
And this total record do not contain. And the entry, there is no order according to the entry of this, the commission of this. Now the matter stopped there because nobody wanted to. Well, when the matter was, before this. That's not the issue. If you take an application, definitely the city office can some even for the settlement. Now you see what is happening to the people was the settlement. Settlement operations are in those time. 12 years. So how many settlement operations are not being held now? 4 settlement operations are not being held.
So far as this situation is concerned, the very cause of action for coming to the Supreme Court, your lordship will find at page 12, that was preparation of duplicate records. Page 79, my lord, para 12. And it is in this context, my lord, the honorable senior judge has passed the order. The petitioner begs to state that after having purportedly acquired lands of the Deguttar, the respondents went on to prepare a Jamabandi of Kamakhya village of Nilachal Hill in 1973. Herein it was referred to as the original Jamabandi.
In your application, have you LSP, apart from the sale deed?
The sale deed and also the GMD's permission is there. And Millard, but they are.
Subsequent documents.
These are subsequent.
GMDA
documents.
on
Yes,
these are
yes,
also
subsequent, because I
recent
came into the picture only in 2007 and 2008, Millard. Those are the.
I'm not been able to come out of the share. Please look at second for you. Now you see, we need together.
No.
Deciding anything containing subsection 1 of section 3 or subsection 1 and 4 are religious or charitable institution, including its individual branches in Delhi, shall, with effect from the date of the state, be established to maintain possession of. Now, this is by operation of the act. The developer says, I can retain.
Yes.
The developer doesn't need permission of the government.
No.
By the statute, of the act itself is that the right that this is my.
Right.
Okay. Free from land, constructing building, raising or the power gardens to a compound appurtenant thereto. Now this compound appurtenant thereto does not limit itself to a bounded land appurtenant thereto. All land reserved for the resident devotees for residential purposes.
These are the lands.
So that has not been asked them for any. Now, if this is so, then we must have connecting documents to say that this is the land required of the government. The government then issued a patta
Subsequently.
from that patta. Again, this will continue that it's not transferable or eligible.
Yes.
So the third party right of discussion never arise.
Yes.
in this land.
Yes.
Now, if the impression of first part is made, then it doesn't change the character of this party. Depends, in fact. If this is so, then why the exercise of schedule number 2 be done? Get to minus, you said that this is guideline. It doesn't matter. And now retainable value, there is also a provision.
Such lands shall be liable full revenue rate.
Six, taking possession of the gateway not sunshine bank of the bank of the institution of the state, constitutionally possession thereof, and may not have purpose to take such step when it is necessary, provided that the thing contained in sections are lead to authorize the developer to take on that remaining maintenance fine. Fine will not take.
Yes.
There is a bit of audio taking photos and the taking some there.
If I may,
You don't have any original documents, it's like. That's what I recollect, I will be wrong, I will take you out from my memory.
But if I'm not mistaken, Millard, their case actually from the writ petition, pleadings in the writ petition, Millard, does not really come under section 5 at all, Millard.
It comes.
Their whole case is on fraud, forgery, that the whole Jamabandi was forged. And that's why the learned single judge, with respect, Millard, said that those are questions, Millard.
Now, please tell me how a third party right can be created, which is alienable and transferable.
Not alienable.
So if by virtue of the statute, can I now draw up a presumption that something must have happened?
Millard, if I may refer to section 3 for a moment, Millard.
Yes,
3, 1 and 2. Because section 3, if I may. Chapter 2.
The state government may from time to time by notification in the official gazette declare that all rights in land belonging to a religious or charitable institution of public nature shall vest in the state free from all encumbrances with effect from the first day of the agricultural year next following the date of publication of such notification. A copy of the aforesaid notification shall be served on the head of the religious or charitable institution in the manner prescribed. And further, it shall be published in the offices of the Deputy Commissioner, Subdivisional Officer, and the Circle Officers within whose jurisdiction the lands are situated, and also in the premises of the religious and the charitable institution concerned. The publication of the notification in the official gazette and the service of the saints as provided under subsection 1 and 2 respectively shall be conclusive evidence of the due publication thereof and notice to all persons affected by such notification. So this notification, my lord, according to the state was published and it was duly served in accordance with section 3, my lord. So therefore thereupon, my lord, rather, the vesting had taken effect.
You can't read this statute in isolation. 3 can't be read in isolation to 5.
And then the consequence of the notification is dealt with in section 4. Notwithstanding anything to the contrary in any law for the time being in force or any custom or any agreement or contract express or implied, on the publication of the notification under section 3, all right, title and interest in the lands of a religious or charitable institute within the subsoil, including the rights in so and so, mines, minerals, fisheries, tanks, wells, forests, grazing reserves, hats, bazaars, roads, and ferries shall cease, and such lands, including such rights, shall vest absolutely in the state, free from all encumbrances with effect from the date specified in the notification. No claim or liability enforceable before the date of publication of notification against the institution for any money which is secured by a mortgage or charges on the lands belonging to such institution which is vested in the state shall be enforceable against the interest of the institution, but such claim and liabilities shall be enforceable only against the compensation against money payable under this act. All suits and proceedings and any orders of attachment in respect of such lands belonging to the institution in connection with the recovery of any money as mentioned in subsection 2, which may be pending on the date of vesting, shall be dropped and shall cease to be in force. Then only comes section 5.
But
And
5 says notwithstanding in 3 and
yes,
4.
yes, my lord, notwithstanding,
These are
but
rights. 3 and 4.
notwithstanding anything contained in subsection 1 of section 3 and subsection 1 of section 4, a religious or charitable institution shall with effect from the date of vesting be entitled to retain possession of, and then they give the things that they can retain.
Here starts the problem. I'll tell you why.
Yes.
There was no exercise at any point of time under this act by the Deputy Commissioner to take over actual possession of the land after determination of the what this
Retainable.
what is it called? Retainable area. That exercise was never done.
But according to the affidavit of the DC, my lord, which was relied upon by the learned single judge, the retainable area exercise was, the earmarking was done. And that is why direction 2, my lord, specifically refers to the.
That is never placed.
Determined already.
Determined.
To verify, determine.
A document which is determined
Yes.
cannot be redetermined by order of, even by the order of the single judge.
May I just read that direction once again, subject to permission, my lord?
Please. That means you see.
Is it a presumption kind of thing? Or
No,
is
it was a
is on
statement made,
records?
it was a statement made on oath by
No,
the.
no, we'll tell you why. You see, this is, in this bench, we have now, everybody has enlightened us on the scope and ambit of certiorari. Now, once there's a determination made by a deputy commissioner, that is not amenable to judicial review under 226. So what we are actually doing is exercising our certiorari jurisdiction to see whether that is right or wrong. Then, if we find that process to be wrong, then we say you revisit it. If the exercise in 1959 was done, let us say 1963, 64, whenever, have we found has this court found fault in that and then say they will revisit it?
No, my lord.
So therefore, an exercise done lawfully, having not been struck down, can there be a revisitation of the same exercise again? You purchase a land. You got permissions, you got everything. Now, can by virtue of order of this court, I say that the purchase of the land be revisited again. No. Why? If I can order direction of two, section direction number 2, why I can't give you direction to Mr. Fukan, against Mr. Fukan?
My lord, if I am within the retainable area, I am definitely out, my
That's
lord.
why, please show us that this exercise was done.
Well, that is something of course the state can do, my
That is
lord.
only an
But
affidavit.
if I may just read
That is
direction
only an
two.
affidavit.
No,
It's an affidavit.
this is affidavit. Where
This is affidavit, my lord, would be there in the records, my lord.
The last 221 is the final affidavit, page 221.
221.
Nothing of such.
Is there anything on that?
No, nothing, nothing. And it will also be clear from the impugned judgment itself at page 293.
Is there a short affidavit?
Page 293, paragraph Roman 11. Yes. The 10th line from the top, Your Lordship, in view of the aforesaid and considering the statement of the DC, it was a mere statement only. And it states that it can still identify the retainable area. Retainable area, our case is that it was never identified. When the impugned judgment was passed, there was a mere statement by the DC that it can still identify.
You see.
On the basis of that, the directions were
You know,
passed, Your Lordship.
How this fallacy can be found out? Page 222.
Yes. Last settlement, it was stated there. At paragraph 3.
In 64 it was there.
You have a copy?
Yes,
My lord.
yes.
Huh.
Paragraph 3 of page 222, Your Lordship.
Fifty-seven to 62.
Yes. And thereafter, they didn't prepare anything. It is their statement.
You can both
All
read
of-
it. I'll read it for you.
Yes, my lord, no,
Don't worry. Page 222, paragraph 3.
yes, my lord. May I read?
Now, no, I have my own way of reading. Please allow me to read that. Now, this paragraph 3, you come to page 223. This is a statement which is matter of record.
Lordship.
This is not by his personal knowledge. Now, see what he is saying. Come to the middle, there is a highlighted portion. In the top, first part of paragraph 3, it does not say about the retainable area. It says how the record of rights are prepared. Then it comes, the last set of record of right in respect of Kamakhya village was prepared in 1957 to 64. Now this act came in 1959. So retainable area, an exercise could not have preceded the actual act. 59 was notified sometime, let us say 59, mid 59 or somewhere. Operations of settlement was started in 59. Now, please understand the implications. Number one, Devotar being the owner of the land, somebody could have either claimed right as an under the non-agriculture area tenancy act, claiming that it is in possession, or it will say that it is a recorded tenant and therefore royalty rights under the what is that act?
Awesome.
Non-agriculture areas tenancy act. They will come under that act. Section 5 is the limitations of how the possession and all comes.
Occupancy, no.
So this exercise, you see, will be based on the retainable area being found, number one. Those land west to the state. The deputy commissioner will have some record to say that how I have taken over the land. Land is always taken over by the Lat Mandal. He will make a inventory of the land being taken. That's why I said in that the earlier occasion, we had an occasion to ask things. And therefore, it's at that point of time, we had lost track.
In that particular case, will take an issue.
In that particular case, because that was by the Devatar. Writ petition was filed by the Devatar.
I think because my lord's memory was fresh when your lordship had actually taken note of the writ petition, which order I have passed, my lord, at page 92, my lord. Because after the learned single judge's order was passed, directing, my lord, that the encroachers may be removed from the retainable areas, and mutation may be continued in accordance with law. That was the last direction of the learned single judge's order. I wrote for mutation. I applied for mutation and no mutation happened.
That, Mr. Pukul. You see, excuse me from being stuck at a point of, at a single point. To section 5, when it says it's non-transferable, first tell us how it became transferable. You see, otherwise there's no settlement process required. Is a devoter land, section 5 says retainable, land X belongs to the state. And then all the rest of land is in the name of the devoter.
Retainable area.
Retainable area. Now the state will have to do an exercise of transferring the land, settling it with someone. Barred under section 5.
By issuing patta as well.
Barred under section 5, enter exercise is illegal. The government by virtue of ownership can't transfer the land. Issuance of patta itself was illegal. That's why I'm stuck at a basic point of, at one point I'm not being able to come out. They have to make an endeavor to make me come out of that blockade. Section 5 can be can be said to have been watered down by any other act of the state. And there's no record of saying, you please come to this again, the paragraph 3 we were reading. Now, as per available, last 3 lines, as per available records, the Lakhiraj and periodic patta Jamabandi of Kamakhya pertains to record of right prepared in 1957 to 64. That is, if you have this Jamabandi,
yes,
we'll come to find out whether this retainable area was determined.
Determined whether there was a retainable area at all
Yes.
or not. Well,
And if this is prepared now, 64, 1973 land records would be illegal. It can't happen unless the government comes up and shows that the settlement period of 57 to 64, which is a 7-year period, culminated in the creation of Jamabandi in the year 1973.
I understand.
Because this, you see, this 7-year exercise means either 7 or 14-year exercise. It means that it starts from a point of time when it culminates in 1 and the settlement operation is closed.
Culminated, yes.
The officer is not now known as a settlement officer. He becomes a circle officer then. He changes his rope from the settlement officer to another rope and then start working. I have to rise. Okay. Fix up some other day. This is a meeting call.
Where? The demarcation, all land falls, they will take away our land. But we are pending.
We'll see to that. We'll see to that.
Because it's not complaining, unless the land is demarcated. We have no fix on, demarcation is made.
We will come to it. Please give us some time. Let us understand. I am stuck at a point of time, at a point. I have to come out of that. Mr. Muzumdar and Mr. Fukan will help us in doing so.
We will assist your lordship, my lord.
Okay. All sides are duly represented. The hearing could not be, the hearing of the applicant side could not be concluded. This again tomorrow?
Tomorrow I can be here.
Okay.
Okay,
Mr. Sharma?
So yes, tomorrow it can be taken, but the service is not yet complete, your lordship, that I should have initially stated.
I don't know, you made us here so long.
This is one area where because of there is a stay on the one hand and so many respondents are there. Lordship possibly will direct the petitioner to
I have furnished
publish in the newspaper so that none of the
newspaper publication may be permitted, your lordship, yes.
But then why we are hearing so much of time?
It's because of the IEA manner. On merit.
No, even IEA we could not have heard it.
Lordship.
So, contribution. Service of notice is something, or in this case, somehow it's not happening. Some are, have appeared, some have not appeared. Lordship will kindly direct the appellant to publish it in the newspapers.
No, whether they were represented in the rate court?
They were.
Why don't you exercise, what you call, order?
Earlier lawyers,
And then,
the earlier lawyers, they are also not accepting the notice. That's all.
but they can't do it. You should have given a complaint to the bar council. They are covered in appeal, order 323, I think, na?
Yes.
Seen the record, they did not take these steps for so many months together.
My suggestion.
No, we have taken
when
steps,
you
Your
said
Lordship.
Lordship is rising also. Lordship will fix sometime in the month of February.
February,
May.
Lordship.
And in the meantime, let them do this exercise of publishing
Yes,
the
Your Lordship.
newspaper, so that
In the local newspaper.
whoever is interested will come.
Yeah, some people, but see,
It appears that a lot of parties have actually, not lost interest, or they are not really interested, because before the writ court also very few landowners were actually represented.
Everything is by design. Because the other side will now have a chance to come up against, and I have not been had
Yes.
review.
So that's why publication may be the best recourse, as Learned Senior is pointed out.
Miss Assistant, since I have to raise as a matter of this file, you just tell us on which respondents it has not been served. Tell it to the court master, I'll pass an order in the chambers.
Yes.
Lordship.
May I request for 27th February, subject to convenience, I can be here physically.
27th. Just tell the court master.
Aye.
not yet.
27.
Deeply obliged.
But take this and then tell us,
let them publish in the newspaper.
we'll see it. Just tell us on whom the notice has not been served.
Lordship.
And in the writ court, who were the lawyers who were appearing for them? Please make a chart, take 5 or 10 minutes of your time
Yes.
and do the exercise. And then we'll pass orders.
Yes.
We'll have to know about the order only tomorrow.
Yes.
But please give us the name of the lawyers who are appearing for them in the writ court. The number of the respondents whom the notice has to be served. So we'll give you 3 days time to take steps for paper publication, but subject to what I find from the recording.
Lordship.
Obliged.
Item 1, review petition 21/2024.
The order is interfered with and the review petition is allowed. And the MFA is restored to file.
Lordship.
Some corrections which have come up will probably get the order tomorrow, not today.
Lordship.